On November 23, 2023, the Israeli Ministry of Defense announced that they had officially concluded an agreement to sell the Arrow 3 air defense system to Germany for an estimated $3.6 billion, describing it as the largest ever defense export of Israel. The Israeli Defense Minister further described the moment as, and I quote, an emotional moment to be here as the son and grandson of Holocaust survivors on German soil in Berlin to sign a defensive arms contracts. It's very important personally and diplomatically. This moment of history leans on our past and dictates our shared future. He called the sale a moving event for every Jew. End of quote. As has been reported many times, Israel is a technological hub, particularly in the weapons industry, and Israeli companies proudly advertise their products as battle-tested. Needless to say that for years the international community has been aware that the testing field is Palestine and its people, particularly Palestinians living in Gaza. Mr. President, the present case is different than that filed against Israel by South Africa, and in which Nicaragua is seeking to intervene as a party. The South Africa case only involves violations of the Genocide Convention by Israel. In the present case, Nicaragua is invoking the responsibility of Germany in connection with the genocide committed by Israel, and also the responsibility of Germany for the violations of its own obligations under the Genocide Convention and of the violations by Germany of its own obligations under international humanitarian law. The cases are thus different with respect to the norms being violated and with respect to the form of the violations. Germany is failing to honor its own obligation to prevent genocide or to ensure respect of international humanitarian law. The violations of international humanitarian law by Israel create obligations for Germany, as it does for all states of the international community, obligations for which Germany is responsible and which are being claimed in the present proceedings. Mr. President, the fact that the acts of one state generate independent obligations for third states is not an unusual legal situation. The first case of the present court, the Corfu Channel case, involved the laying of mines in Albanian waters that caused damages to the United Kingdom vessels. The court found no evidence that Albania itself had laid the mines or that it had colluded in the laying of the mines by a third party. But it was established to the satisfaction of the court, including by the report of experts appointed by the court, that, and I quote, laying of the minefield could not have been accomplished without the knowledge of the Albanian government, end of quote. And having that knowledge, open quotes again, the obligations incumbent upon the Albanian authorities consisted in not notifying, for the benefit of shipping in general, the existence of the minefield, end of quote. This ruling in the Corfu Channel case was taken up by the International Law Commission in the following manner, and I quote, a state may be required by its own international obligations to prevent certain conduct by another state, or at least to prevent the harm that would flow from such conduct. Thus, the basis of responsibility in the Corfu Channel case was Albania's failure to warn the UK of the presence of mines in Albanian waters which had been laid by a third state. Albania's responsibility was original and not derived from the wrongfulness of the conduct of any other state. End of quote. This judgment was one of the bases for the general rule contained in Article 16 of the Articles of Responsibility of States for Internationally Wrongful Acts, providing that a state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if that state does so with knowledge of the circumstances of the international wrongful act. It is pertinent to point out that the International Law Commission makes a special note of the situation when the responsibility arises from a serious breach of peremptory norms of general international law, which is the situation we are dealing with in the present case. In these circumstances, the International Law Commission comments that there is no need to mention the requirement of knowledge of the circumstances in Article 41, paragraph 2 of the Articles on Responsibility, as I quote, "It is hardly conceivable that a state would not have notice of the commission of a serious breach by another state," end of quote. Mr. President, permit me to emphasize what the International Law Commission is pointing out. The violations of peremptory norms are facts that are evident and of public knowledge. These are not facts that can only be established by special authority and that can only be acted upon until they have been so established. They are facts that must be acted upon as soon as they have become known. The importance of this knowledge of the violations has been reiterated in other cases, and Professor Pillay will go briefly into some of them, since a short pleading on provisional measures is not the appropriate moment to go deeply into this question. Notwithstanding, a brief review of the reasons why Germany must have had knowledge and full awareness of what was happening and is happening in Palestine is useful. From the first days of the Israeli military actions in Gaza, it became evident that grave violations of international humanitarian law were being committed. Statements pointing this out were urgently made, among others, by the Secretary General of the United Nations on 9 October, by the President of the International Committee of the Red Cross on 11 October, and even at a political level with full participation of Germany in the statement by the High Representative of the European Union on 10 October, all of these on 2023. From that moment, even if the genocidal intent was not yet entirely evident, the grievous violations of international humanitarian law were evident. In practice, it was not even necessary to await these declarations in order to realize that, for example, dropping bombs of 1 ton in densely inhabited areas was a completely unjustifiable violation of the most basic humanitarian laws that had been recognized as such for many years, centuries in reality. If those statements just mentioned were not enough information to trigger the obligatory response by Germany, in your folders is a non-exhaustive list dating from 9 October until last Friday, 5 April, of 32 statements from hundreds of the most respected authorities, organizations, experts, legal scholars, and practitioners on questions of international humanitarian law, calling out that Israel was breaching or plausibly breaching the Genocide Convention and that it was breaching the most important norms of international humanitarian law. This ever-growing list includes the recent open letter of more than 600 legal experts, including 3 Supreme Court justices, calling the United Kingdom government to end weapons sales to Israel, as well as the resolution with a similar but universal call from the Human Rights Council of the 4th April, not surprisingly, with Germany's negative vote. With all this undeniable knowledge of the situation, Germany's reaction was to increase its military assistance to Israel. Its complete support of Israel, even at the political level, was manifest when South Africa filed its application on Israel on 29 December 2023. The prompt reaction of Germany was to announce that they would intervene in favor of Israel. But apart from all these public statements and warnings of what was happening, the court, in its order of 26 January, considered that genocide was plausibly being committed against the Palestinian people. From that moment on, paraphrasing one of your members, the alarm was sounded and the indications of genocide activities were flashing red. With the alarm sounded, in fact, it was a final alarm, resounding amid a horizon of alarms from all quarters, there should have been no further possibility of ignoring the situation. And yet Germany continued and still continues to this day to supply weapons and military assistance in general to Israel. The norms of the Genocide Convention, which are part of customary international law, impose the obligation on third states to undertake to prevent genocide. This obligation arises from the moment that that state becomes aware that genocide might be committed. And there can be no question that Germany, as is evident from the preceding comments, was well aware and is well aware of at least the serious risk of genocide being committed, most certainly after your order of 26 January. The consequences of the violation of this obligation will be further addressed by Professor Pillay. In the present case, In addition to the obligations under the Genocide Convention, we are also invoking violations to other peremptory norms of public international law, particularly the norms of international humanitarian law of the Geneva Conventions, which are also norms of customary international law. Many of the violations of these norms are also part of the constitutive elements of the crime of genocide. For this reason, even if genocide were found to not have been committed, which Nicaragua does not accept, these violations of international humanitarian law stand alone and involve obligations for third states. A grievous example of this can be appreciated in the violations, among others, of Articles 55 and 56 of the Geneva Conventions and the duties of the occupying power of ensuring food and medical supplies for the occupied population. On this point, the Court noted in its order of 28 March, and I quote, "The unprecedented levels of food insecurity experienced by Palestinians in the Gaza Strip over recent weeks, as well as the increasing level of epidemics." End of quote. As one of your members pointed out, these circumstances also reflect a plausible risk of a violation of relevant rights under the Genocide Convention. But even if it were found, quod non, that provoking this famine and catastrophic situation does not amount to genocide, it is in and by itself a clear violation of the Geneva Conventions. These norms also impose obligations erga omnes, which Germany, like all other states of the international community, is bound to respect, and therefore the violations of these norms in the binding aspects that they have on third parties can be claimed, are being claimed by Nicaragua against Germany as part of this case before the Court. In view of the catastrophic situation of famine and epidemics in Gaza, the decision of Germany to suspend the funding of UNRWA and to maintain to this day the suspension of the funding of UNRWA's operations in Gaza is particularly telling of Germany's support of Israel. The question of the suspension of the funding will be reviewed by Dr. Mueller. At this point, some brief comments. UNRWA has been working in Palestine almost as long as the existence of Israel as a state. It has been providing the essential needs of the many refugees in the area. During this military campaign of Israel in Gaza, nearly 200 humanitarian workers, the majority of whom were part of the staff of UNRWA, have been killed. Israel accused about a dozen of the more than 12,000 workers of UNRWA with involvement in the events of 7 October. Immediately, and based on the sole say-so of the Israeli government, Germany suspended its funding of UNRWA. Incredibly, this occurred the day after your order of 26 January. What is striking in respect to this reaction of Germany is that on the say-so of Israel, they suspended assistance to UNRWA, but they have ignored the statements and the accusations of the most important world authorities that genocide and other violations of international humanitarian law were being perpetrated by Israel in Palestine, and continued their full assistance, including military assistance to Israel. Moreover, possibly realizing the absurdity of such a decision, Germany finally reversed its decision, except for the most shocking aspect, the suspension of funding for UNRWA operations in Gaza, precisely where it is most needed to limit the scale of the humanitarian disaster. Mr. President, up to this point, Germany has had the opportunity of studying our application and will have the opportunity of listening to our pleading today and responding tomorrow. Nicaragua has not had the opportunity to be informed of the position of Germany on the legal issues involved. The only reactions of which we have noticed are those mentioned in our application. They amount to simply indicating that Germany rejects Nicaragua's claims, as well as other publications, other declarations justifying the backing of Israel's actions. From the public statements made by Germany, we could note two alleged justifications for the continued support of Israel: that Israel is not violating the Genocide Convention and that it has a right to defend itself. With respect to the first point, we already pointed out the full knowledge of Germany had and has of what is happening in Palestine and the legal consequences of this knowledge, not only of the plausible violations of the Genocide Convention, but also of the norms of international humanitarian law. This is not a question that can be or need be addressed during these pleadings. that are inevitably short since they are addressed basically to the issues involved in the request for provisional measures. In any case, Professor Pollet will have some further comments on this issue. With respect to the second point, the right of self-defense of Israel, which is also invoked by Germany for its continued assistance, some brief comments. The question of the right of Israel to defend itself is correct if it refers to the right to protect its people and not the right of self-defense contemplated in Article 51 of the United Nations Charter. But in the exercise of the right to protect its citizens, Israel, as occupying power, has assumed the duty to, and I quote from the regulations concerning the laws and customs of war and land, I quote, take all the measures in its power to restore and ensure as far as possible public order and safety while respecting, unless absolutely prevented, the laws in force in the country, end of quote. In practice, this implies that the police or general security powers the occupant has are similar to those of the state occupied. This right of protection is a right that frequently has to be exercised by states, even in difficult circumstances. But even in the most blatant situations of violence, the state has to respect the peremptory norms of international law. Mr. President, this is the bottom line. On whatever basis or definition a so-called right of self-defense is invoked, it can never serve to justify violations of the norms of the Genocide Convention or other norms of international humanitarian law. Surprisingly, Germany seems not to be able to differentiate between self-defense and genocide. Furthermore, Germany cannot invoke that Israel is in some state of necessity of its assistance for its defense and survival. In spite of its size and population, Israel is in the top 10% of the most militarily powerful countries in the world. Its per capita expense is more than 4 times larger than that of Germany. It is even higher than that of the United States. Its total yearly military expenditure, going back many years, is higher than that of its neighbors, Iran and Egypt, that have a population more than 10 times larger and immense territories in comparison with Israel. Mr. President, 2 considerations can also be briefly added on the question of the attacks that occurred on 7 October, which to our knowledge have not been taken into account by Germany. Firstly, the Palestinian people have the right to self-determination. That means that they have the right to take up arms against alien occupation and against racist regimes in the exercise of their right of self-determination, as enshrined in the Charter of the United Nations and the Declaration of Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter. This right must be exercised in line with the norms of international law as integrated in Article 1, Paragraph 4 of the 1977 General Protocol No. 1. Any violations of these norms that occurred on 7 October are not justified by the right of self-determination, but do not terminate this right of the Palestinian people, and even less the right to exist as a people. The second consideration that is sidelined is that the events on 7 October did not occur in a void, on the spur of the moment, without any provocation. This was pointed out a few days after the events of October 7 by the Secretary General of the United Nations speaking before the Security Council. He stated, and I quote, "It is important to also recognize the attack by Hamas did not happen in a vacuum. The Palestinian people have been subjected to 56 years of suffocating occupation." End of quote. If it were necessary to confirm the truth of the statement of the Secretary General, it is not necessary to make an interminable list of the suffering of the Palestinian people since the Nakba in 1948. If we could simply recall the statement that the Secretary General himself had made 3 years earlier on 21 May 2021 in an address to the United Nations General Assembly. He said, and I quote, "If there is a hell on earth, it is the lives of children in Gaza today." End of quote. Today was 3 years ago, before 7 October. Mr. President, members of the Court, if the actions of Israel continue unrestrained as they have since its birth as a state, and they continue to receive the indiscriminate support of states like Germany, then a new generation of Palestinians will rise up again in the near future, and we will hear a future Secretary General commenting, This did not happen in a vacuum. The case before the court is an opportunity to break this vicious cycle. Without support of states like Germany, Israel will not feel it can act with total impunity. Nicaragua is hopeful that states, particularly with the history of Germany, will heed the decisions of this court. Thank you, Mr. President, members of the court. With this, I end my presentation. And may I please ask you, Mr. President, to give the floor to Dr. Daniel Mueller. Thank you.
I thank the agent of Nicaragua for his statement. I now invite Mr. Daniel Miller to take the floor. You have the floor, sir.
Thank you, Mr. President. Mr. President, members of the court, my task this morning is to set out some of the facts underlying the dispute between Nicaragua and the Federal Republic brought before the court. I shall, of course, concentrate on those facts that are relevant for the request for provisional measures. Nicaragua has already explained the factual background in its application. Unfortunately, since then, the situation has evolved further, and in light of that, provisional measures are becoming increasingly more urgent and necessary. Mr. President, members of the court, you are already acquainted with the devastating situation in Gaza and the imminent risk to which the Palestinian people, children, women and men in Gaza, but also in other parts of the occupied Palestinian territory, is currently exposed. 10 days ago, you qualified the living conditions imposed on Palestinians as catastrophic and the most recent developments in Gaza as exceptionally grave. The court knows and has acknowledged that there was an imminent risk of irreparable harm to the rights of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Genocide Convention. And you concluded twice that the situation was such as to justify provisional measures aimed at protecting the right of the Palestinian people in Gaza as a people. In fact, measures aimed at ensuring their sheer existence and survival as a group. You also considered that the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating. Since the end of January, the situation has indeed worsened and deteriorated. Already on 16th of February, the court endorsed the grave concerns expressed by the United Nations Secretary General before the General Assembly and noted that, and I quote, "The most recent developments in the Gaza Strip and in Rafah in particular would exponentially increase what is already a humanitarian nightmare with untold regional consequences." Yet, what was then a desperate call for reason, action and change has turned into blatant and brutal reality. The situation has increased the nightmare. The nightmare is increasing every single day. The Republic of Nicaragua draw your attention to the escalation of the situation in Gaza in its application and its request for provisional measures, and again in the letter of its agent dated 7th of March. The Republic of South Africa reiterated it again in its request of 6 March. In your order of 28 March, you also acknowledged that the catastrophic humanitarian situation in the Gaza Strip has deteriorated even further. Mr. President, members of the court, this is still the reality in Gaza. Only 2 weeks ago, the United Nations Secretary General, visiting Egypt and the border with Gaza, made the horrifying comment that, and I quote, "Looking at Gaza, it almost appears that the 4 horsemen of war, famine, conquest and death are galloping across it." And he continued, "Nothing justifies the abhorrent October 7 Hamas attacks and hostage-taking in Israel, but nothing justifies the collective punishment of the Palestinian people." End of quote. The world is aware of all of that, and the world cannot turn its eyes away. The risk, if this term is still appropriate, of irreparable harm to the rights of the Palestinian people in Gaza to be protected from acts of genocide and to live in dignity is very real indeed, imminent and grave. As recently as last Friday, the UNRWA director reported to the Security Council on the unconscionable brutality of the conflict and confirmed again the tragic reality that there is no protection of civilians in Gaza. While the world is witnessing the destruction of Gaza and its life, the situation in the remainder of the occupied Palestinian territory has been deteriorating too. Last February, the Minister of Foreign Affairs of Palestine described at this bar the suffering of the Palestinian people throughout the occupied Palestinian territory, subjected to the colonization of their territory, to the racist violence that enables it, to the denying of their fundamental rights, to the most inhuman segregation and apartheid, to the negation of their very existence. Day by day, raids, airstrikes, violence against and illegal detention of Palestinians in the West Bank are intensifying. Members of the Court, the Federal Republic was and is aware of the situation and in any event could not have ignored it. Despite the very many warnings, alarming reports and messages of the United Nations Secretary General, United Nations Special Rapporteurs, the International Red Cross, and even the European Union's High Representative, Germany continues to assure and implement full support to Israel for its war against Gaza and its population. Addressing the Bundestag on 12th of October 2023, the German Chancellor stated, and I quote, "At this moment, there is only one place for Germany, the place at the side of Israel. That is what we mean when we say that Israel's security is a German raison d'etat. Our own history, our responsibility arising from the Holocaust, makes it our perpetual duty to stand up for the existence and security of the State of Israel. This responsibility guides us." The Minister for Foreign Affairs said the day before, and I quote her, "Israel's security is a German raison d'etat. With this understanding, I have offered Israel all our support in every area." This was also confirmed by the spokespersons of the federal government and the Federal Foreign Office, who both underlined that solidarity with Israel is paramount. Germany's support to Israel in every area, and in particular in the form of supplying weapons of war, was immediate. On 12th of October 2023, the Federal Minister for Defense confirmed in Brussels that Germany had allowed Israel's air forces to use 2 Heron military drones for what he called Israel's defense battle. The widespread and indiscriminate destruction caused by unmanned aerial vehicles like these drones to civilians, to civilian infrastructure, to houses and homes, and to humanitarian aid workers had been widely reported. In early November, a representative of the Federal Ministry of Economy and Climate Protection confirmed that, due to the situation, the German government processed and decided on applications for the export of military equipment to Israel as a matter of priority. The German government had authorized for the year 2023 exports of military equipment and war weapons in the amount of more than 326 million euros. Although Germany was even before October 23 Israel's second most important supplier of military equipment, this figure shows that export licenses granted by the Federal Republic are more than 10 times as important as for the year 2022. Most of these licenses were granted in the second half of 2023, after the invasion of Gaza by Israel and the start of its war in the territory and against its population. Indeed, according to the official figures of the German government, until 30 June 2023, only licenses in the volume of 38 million euros had been granted. In other words, export licenses for military equipment worth almost 300 million euros had been delivered by German authorities as a matter of priority within and against the background of the specific situation of Israel's war in Gaza and against its population. This includes export licenses for weapons of war in the value of 20 million euros, such as 3,000 anti-tank weapons, which according to one manufacturer in Germany are a complete toolbox of shoulder-launched infantry weapons used against tanks, but also vehicles, structures and buildings, and persons. 500,000 rounds of machine gun ammunition, 44 propellant charges, a key component in artillery ammunition, and 239 ignition charges. These are weapons built to and aimed at destroying and killing. Or to quote from Germany's own definition, objects and substances capable of causing destruction or damage to persons or property and of serving as a means of using force in armed conflicts between states. In early 2024, the German federal government continued to provide export licenses for military equipment and weapons of war. According to the data submitted by the government to the members of the Bundestag, these licenses concerned military equipment of a value of more than 9 million euros. And despite requests made by members of the Bundestag concerning more recent data, at the best of our knowledge, no further information has been made available by the federal government since the introduction of the present proceedings. Mr. President, although those figures are telling, they do not reflect the full picture of the military support provided by Germany and the German industry to Israel's war in Gaza. These figures do not include export of equipment that does not fall under the export license requirements. They do also not include supply of military equipment directly by Germany to Israel. And the German news magazine Der Spiegel revealed information about plans of the German government to deliver tank ammunition from the stocks of the German armed forces. Moreover, due to the very dense and intense cooperation between Germany and Israel, also in terms of military equipment and exports, a great part of the military machinery and equipment of Israel is, at least partially, from Germany and depends on supplies, motors, engines and spare parts from Germany too. Israel saw 6 corvette warships built by the German group ThyssenKrupp and sold with the support of the German government in 2015 have been used since October against Gaza and its people. And German manufacturer Mercedes is under contract with Israel's armed forces, in particular for the delivery of tank carriers, and has speeded up its operation amidst the war. Of course, Germany could not and did not ignore the situation in Gaza, largely documented by the press, official reports and statements. Germany could not and did not ignore the likelihood that its support, the military equipment and the weapons of war, would be used by Israel to bomb and kill thousands of Palestinian children, women and men. These questions were raised time and again, and this from the very beginning of the large-scale invasion of Gaza. Already on 11th of October, the spokesperson of the Federal Foreign Office was asked very directly whether the military actions of Israel were in conformity with international humanitarian law. He eluded the question and replied that, and I quote, "Israel has the right under international law to defend itself against the current attack, the terrorist attack by Hamas. We support this right and we stand by Israel's side," end of quote. And he added simply in passing that, and I quote again, "Of course, even in this absolutely exceptional situation, the protection of the civilian population is a requirement of international humanitarian law," end of quote. On 8 November, the federal government was specifically asked whether, to its knowledge, Israel is fully complying with the relevant norms of international law, international humanitarian law, and refugee law in its current military operations in the Gaza Strip. In its response, the government confirmed that under the relevant legal framework, export licenses must be denied if there is a clear risk that the military technology or equipment to be exported might be used to commit serious violations of international humanitarian law. And despite the numerous reports on the concrete situation in Gaza, which Germany could not have ignored, the government representative continued, and I quote, "Israel assures the German government that it is taking precautions to ensure compliance with the requirements of international law. The German government currently sees no reason to doubt this." Against the continuing reports on the catastrophic situation in Gaza, the German authorities seem to have finally started to doubt Israel's assurances. On 25 January 2024, the federal foreign minister declared that, and I quote, "Notwithstanding the right to self-defense, there are rules, and the international humanitarian law also applies in the fight against terrorists. Israel needs to respect these rules just like all other states in the world, even in the difficult environment in which Hamas is breaking them all and using people as human shields." However, irrespective of these assertions, and indeed the very clear risk that grave violations of humanitarian law and international law are committed in Gaza, recognized by your court, Germany has not suspended its military support. The Federal Republic, together with all other European Union member states, again expressed its concerns about the humanitarian situation in Gaza and the suffering of the hostages, as well as the Israeli government's plans for a possible ground operation in Rafah on 19 February 2024. It recalled in this context the importance of ensuring the protection of all civilians at all times in line with international humanitarian law, and to respect the 26 January order of the International Court of Justice, which is legally binding. Yet again, no suspension of its military support for Israel. Germany did also not move after the Court of Appeal of The Hague concluded that there were many indications that Israel has violated the humanitarian laws of war, and ordered the Kingdom of the Netherlands to cease all actual export and transit of F-35 parts, with final destination Israel. The Canadian Parliament recalled that, and I quote, "Israel must respect international humanitarian law, and the price of defeating Hamas cannot be the continuous suffering of all Palestinian civilians," end of quote. The Canadian government stopped approving exports of military equipment like other states before. Germany did not. Members of the court, if Germany might not have doubted the assurances of Israel in October 2023 as it claimed then, this is simply not tenable anymore. On 24 March, the federal foreign minister referred to the hell of Gaza and the dire situation of people starving to death. She also underlined that military action has its limits in international humanitarian law. And during her visit in Tel Aviv, Ms. Baerbock announced that Germany will send a delegation to Israel to discuss questions of international humanitarian law because, and I quote, as a signature of the Geneva Convention, Germany is obliged to remind all parties of their duty to abide by international humanitarian law, end of quote. And still yesterday, it was reported that a group of 600 German civil servants was calling on the government to cease armed deliveries to the Israeli government with immediate effect, exactly because, and I quote, Israel is committing crimes in Gaza that are in clear contradiction to international law and thus to the Constitution, which we are bound to as federal civil servants and public employees. Nevertheless, Germany still has not taken the decision to suspend its military support and the export of military equipment to Israel. Rather, in a recent response to a series of questions asked by members of the Bundestag, the government reiterated its position that export licenses will be considered on a case-by-case basis and in light of specific circumstances. Members of the court, to put it simple, highest German officials have recognized that the situation in Gaza raises doubts about the respect of elementary rules of international law, and that these questions need to be addressed. Yet, while we speak, the export of German weapons and military equipment to Israel, likely to be used for committing these grave violations of international law, is continuing. The German government has also not made any declaration concerning the stop of its military support to Israel after the United Nations Security Council demanded an immediate ceasefire. Contrary to the Canadian or the Dutch governments, it has not decided to stop nor suspend its supplies of arms to the Israeli government, nor has it resumed its funding of UNRWA's humanitarian operations in Gaza. The fact that Germany is engaged in facilitating or improving humanitarian aid in Gaza and for its suffering people does not change the picture. It is indeed a pathetic excuse to the Palestinian children, women and men in Gaza to provide humanitarian aid, including through airdrops, on the one hand, and to furnish the weapons and military equipment that are used to kill and annihilate them, and to kill also humanitarian aid workers, as most recently evidenced by the missile attack against vehicles and workers of World Central Kitchen, on the other hand. Humanitarian aid in itself cannot keep the hope for peace alive, as demanded by Ms. Baerbock, in particular if the safety of those delivering this aid is not guaranteed and their work hampered. To take the words of the European Union High Representative Josep Borrell, and I quote, "If you believe that too many people are being killed, maybe you should provide less arms in order to prevent so many people from being killed. It is a little bit contradictory to continue saying that there are too many people being killed. Too many people being killed, please take care of people. Please do not kill so many. Stop saying please and do something." End of quote. Yet Germany continues to say please without doing what it is supposed to do. In fact, required under international law to do, stopping its support, in particular its military support, and ensuring compliance by Israel with international humanitarian law. Mr. President, this brings me to the last point I want to quickly touch upon. Germany did not only not do something about its military supply and aid, it also decided to suspend its contribution to UNRWA that is supposed to take care of people in Gaza. There is no question that Germany fully appreciates the importance of UNRWA for the Palestinian people in Gaza and elsewhere in the occupied Palestinian territory. Before 7th of October 2023, Germany was by far one of the most important donors to the agency, its second most important contributor. After having suspended its development aid to the occupied Palestinian territory in October 23, the Federal Ministry for Economic Cooperation and Development released funds initially earmarked for UNRWA's operation in Gaza on 7th of October 2023. The Federal Minister recognized then that, and I quote, UNRWA is the most important partner for providing assistance to the people in the Gaza Strip, end of quote. On 13th December 2023, the German authorities confirmed that the review of allegations of misuse was completed and that the safeguards are robust and that no indications of the misuse of funding have been found. They further explained and recognized the central role of UNRWA for the Palestinian people in Gaza, and I quote, "The first focus of the review was activities that ensure the provision of basic services for the people, especially for particular vulnerable groups. This is why the projects run by the UNRWA, which provide life-saving services, were first reviewed and approved, followed by projects under Germany's transitional development assistance, which are making a direct contribution towards services for civilians in the current crisis." End of quote. The central and vital role of the Agency for the Palestinian People and its sheer existence, fully recognized and endorsed by the Federal Republic, had also been recalled by the United Nations Secretary General. UNRWA was and remains the backbone of the humanitarian distribution in Gaza. No other organization has a meaningful presence inside Gaza, and there is no other organization that would be able now to replace UNRWA. This remains the case today, as recently recalled on last Friday in the Security Council and in the Human Rights Council. Nevertheless, and in full knowledge of the consequences, Germany suspended its funding of UNRWA's operation in January 2024 amidst still unsupported accusations against the agency, and this despite immediate action taken by UNRWA to address these accusations and Germany's previous own assessment of the robustness of the control mechanisms. The suspension of funding deprived the agency of $450 million, with no capacity to absorb this financial shock, in particular in the pressing situation of war raging in Gaza. UNRWA's Commissioner General urged, and I quote, countries who have suspended their funding to reconsider their decisions before UNRWA is forced to suspend its humanitarian response. The life of people in Gaza depend on this support, and so does regional stability. End of quote. Germany acknowledged, while still authorizing supply of military equipment, that the humanitarian situation in Gaza is catastrophic and the situation of the people there is becoming more desperate with each passing day. Yet it has not, to this day, resumed the funding of the operations of UNRWA in Gaza, which were needed more than ever. Nicaragua does of course welcome the decision of the German authorities to provide new funds to UNRWA's operation in Jordan, Lebanon, Syria and the West Bank. But still, the much-needed support for the agency's central and life-saving operations in Gaza remains suspended. This unjustified decision contributes to the suffering in Gaza, where children, women and men are starving, a situation created by the attempts to ensure the defunding of the agency. According to UNRWA, it is lacking 35% of the forecasted income for 2024. For good reason, this court has considered on 28th of March 2024 that in view of the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, it is necessary to, and I quote the court, take all necessary and effective measures to ensure without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance. Mr. President, members of the Court, I thank you for your attention, and Mr. President, may I ask you to give the floor to Professor Alain Pellet.
I thank Mr. Miller for his statement. J'appelle maintenant Monsieur le Professeur Alain Pellet à la barre. Vous avez la parole, Monsieur le Professeur.
Monsieur le Président, Mesdames et Messieurs de la Cour, l'Allemagne n'est pas juridiquement responsable de l'enfer qui s'est installé à Gaza, ou plutôt, elle ne l'est que de ses propres manquements à ses propres obligations internationales liées à cette épouvantable situation. Et elle l'est dans la mesure où ces manquements ont rendu possible ou facilité les violations graves des normes fondamentales du droit international général commises à l'encontre du peuple palestinien, non seulement dans la bande de Gaza, mais également dans les territoires occupés et en Israël même. C'est ce qui justifie la requête du Nicaragua contre l'Allemagne, aussi bien que la demande en indication de mesures conservatoires qui motive l'audience de ce jour. Je pense pouvoir passer rapidement sur la question du jus-stand-dit du Nicaragua. Comme vous l'avez excellemment rappelé dans votre ordonnance du 26 janvier dernier, en vous référant à l'affaire qui oppose la Gambie au Myanmar, je cite, « Tous les États partis à la Convention sur le génocide ont, en souscrivant aux obligations contenues dans cet instrument, un intérêt commun à veiller à ce que le génocide soit prévenu, réprimé et puni. Ce sont des obligations erga omnes partes que chaque parti et État parti a un intérêt à faire respecter, notamment par l'introduction d'une instance devant la Cour. Mutatis mutandis, il en va de même dans la présente affaire. L'Allemagne et le Nicaragua sont partis à la Convention sur le génocide, dont ils tirent l'une et l'autre des obligations et des droits qu'ils sont fondés à invoquer devant vous. Toutefois, notre agent y a insisté, les demandes du Nicaragua ne se limitent pas à des violations de la Convention de 1948, elles portent également sur les violations par l'Allemagne des obligations qui lui incombent en vertu des 4 conventions de Genève de 1949, y compris la 4e, relative à la protection des personnes civiles en temps de guerre, et de leur protocole de 1966. Nos demandes portent aussi sur d'autres de ces manquements de l'Allemagne à d'autres traités pertinents protégeant les droits de l'homme ou concernant le droit international humanitaire. Toutes ces conventions énoncent des obligations erga omnes partes que tout État parti a un intérêt juridique à faire respecter, y compris par l'introduction d'une instance devant la Cour. Comme vous l'avez souligné dans l'avis sur le mur, je vous cite, « Tous les États partis à la Convention de Genève relative à la protection des personnes civiles en temps de guerre du 12 août 1949 ont l'obligation, dans le respect de la Charte des Nations Unies et du droit international, de faire respecter par Israël le droit international humanitaire incorporé dans cette convention. » Fin de citation. En outre, en tant que membre de la communauté internationale des États, le Nicaragua prie la Cour de constater et sanctionner les violations graves par l'Allemagne des obligations lui incombant en vertu de normes impératives du droit international général dans ces mêmes domaines, qu'il s'agisse de ses devoirs de prévention et de répression des crimes de génocide ou d'apartheid, de violation de principes fondamentaux en matière de droits de l'homme ou de droits humanitaires, ou de son droit à demander réparation dans l'intérêt du peuple palestinien. Ici encore, les constatations faites par la Cour dans Gambie contre Myanmar et rappelées dans votre ordonnance du 26 janvier doivent s'appliquer pleinement. Comme vous l'avez indiqué dans votre avis consultatif sur la licéité de la mesure ou de l'emploi d'armes nucléaires et rappelé sur la licéité de la menace, ou de l'emploi d'armes nucléaires et rappelé dans celui sur le mur, je vous cite, un grand nombre de règles de droit humanitaire, du droit humanitaire applicable dans les conflits armés sont si fondamentales pour le respect de la personne humaine et pour des considérations élémentaires d'humanité qu'elles s'imposent à tous les États, qu'ils aient ou non ratifié les instruments conventionnels qui les expriment, parce qu'elles constituent des principes intransgressibles du droit international coutumier. De l'avis de la Cour, les règles en question incorporent des obligations revêtant par essence un caractère erga omnes. Fin de citation. Je remarque en tout état de cause qu'à ce stade, il vous incombe seulement de vous prononcer sur votre compétence prima facie, sans que vous ayez besoin de vous assurer, je vous cite, de vous assurer de manière définitive que vous avez compétence quant au fond de l'affaire. A fortiori, vous n'êtes pas appelés aujourd'hui, mesdames et messieurs les juges, à exercer votre compétence au fond. À ce stade, il vous appartient seulement d'indiquer les mesures urgentes de nature, et je vous cite à nouveau cette fois, à sauvegarder les droits que l'arrêt que vous aurez ultérieurement à rendre pourrait reconnaître au Nicaragua. C'est que la jurisprudence de la Cour repose sur une distinction entre deux notions différentes. D'une part, l'existence de la compétence de la Cour et de l'autre, l'exercice de cette compétence lorsqu'elle est établie. Qu'en l'espèce, la compétence de la Cour soit établie prima facie pour se prononcer sur la requête ne peut faire aucune espèce de doute. Votre jurisprudence récente le confirme à suffisance et cela suffit pour vous donner également compétence pour indiquer les mesures conservatoires demandées. Cela suffit aussi pour écarter l'objection que l'Allemagne ne manquera très probablement pas d'invoquer demain, fondée sur le principe de l'or monétaire, alors même qu'il s'agit par excellence d'une question qui relève non pas de l'existence de la compétence, qui ne saurait faire de doute, mais de son exercice. Même si les circonstances dramatiques de l'affaire qui vous est soumise aujourd'hui ne se prêtent guère à l'exposé d'états d'âme doctrinaux, permettez-moi de dire, Monsieur le Président, que je n'ai jamais compris l'utilité de ce prétendu principe, bien qu'il ait été énoncé dans une affaire présentant des caractéristiques tout à fait exceptionnelles. La Cour y a proclamé son attachement à plusieurs reprises au prix d'acrobaties intellectuelles qui me semblent parfois outrancières. S'il s'agit seulement de dire que la compétence de la Cour est fondée sur le consentement, l'article 59, combiné avec les possibilités d'intervention que le statut offre aux États en tant que partie ou non, l'article 59 me paraît suffire à la besogne. Comme vous l'avez d'ailleurs rappelé, citant l'arrêt numéro 11 de la Cour permanente, je cite, « Le but de l'article 59 est d'éviter que des principes juridiques admis par la Cour dans une affaire déterminée soient obligatoires pour d'autres États ou d'autres litiges. » Et il résulte clairement de cette dernière disposition que les principes et règles de droit international que la Cour aura estimés applicables dans les relations entre le Nicaragua et l'Allemagne et les indications qu'elle aura données quant à leur application pratique ne pourront pas être invoqués par les parties à l'encontre de tout autre État. Fin de citation. Mais admettons que le principe de l'or monétaire soit autre chose qu'une invention prétorienne conjoncturelle et sinon superflue, du moins clairement sans pertinence en la présente espèce. Et prenons-le sérieusement, deux arguments au moins doivent vous conduire, mesdames et messieurs les juges, à l'écarter. D'une part, comme je viens de le dire, la question ne se pose pas au stade des mesures conservatoires dans lequel il ne vous est pas demandé de vous prononcer sur le fond, au fond sur la situation juridique ou factuelle résultant de la violation des principes juridiques applicables. D'autre part, et de toute manière, il ne suffit pas que l'arrêt à intervenir soit, je cite, susceptible d'avoir des incidences sur les intérêts juridiques d'un État qui n'est pas partie à l'instance pour que le principe de l'or monétaire, si principe il y a, trouve à s'appliquer. Dans les termes mêmes utilisés dans l'arrêt de 1954, il n'en va ainsi que si la question essentielle, the vital issue, à trancher, a trait à la responsabilité internationale d'un État tiers. C'était le cas dans l'espèce très particulière de 1954, dans laquelle l'Italie demandait expressément à la Cour de décider que les gouvernements des États défendeurs lui remettent la quote-part d'or monétaire normalement dévolue à l'Albanie. Mais ce n'est pas le cas dans l'affaire qui nous occupe aujourd'hui, dans laquelle aucune demande ne porte sur un droit quelconque d'un État tiers. La position prise par la Cour dans l'affaire de l'or monétaire ne saurait être utilisée pour empêcher la Cour de se prononcer sur d'empêcher la Cour de se prononcer sur une sur des demandes concernant un État qui accepte de se présenter devant elle. Monsieur le Président, c'est évidemment la requête qui, dans chaque affaire, permet de déterminer quelle est la question essentielle à trancher. En l'occurrence, la lecture de la requête introduite par le Nicaragua le 1er mars ne laisse aucun doute sur son objet. Il n'est pas de savoir si Israël a manqué à ses obligations internationales, mais bien si l'Allemagne a manqué aux siennes. Dans votre ordonnance du 26 janvier, vous avez considéré que la Cour n'est pas appelée à se prononcer définitivement sur le point de savoir si les droits de l'Afrique du Sud, que l'Afrique du Sud souhaite voir protégés existent. Il en va de même dans la présente espèce, dans laquelle, à ce stade, la Cour est seulement appelée à déterminer si les droits que le Nicaragua revendique et dont il sollicite la protection sont plausibles. Ici encore, je ne pense pas qu'il soit nécessaire de vous faire perdre un temps précieux, ni de dilapider les minutes comptées dont nous disposons pour développer exagérément ce moyen. Dans votre sagesse, vous avez limité et vous limitez de plus en plus drastiquement le temps laissé aux échanges contradictoires entre les parties. Dans cette même ordonnance du 26 janvier, vous vous êtes déclaré, je vous cite, d'avis que les faits et circonstances que vous aviez relevés alors suffisaient pour conclure qu'au moins certains des droits de l'Afrique du Sud, que l'Afrique du Sud revendique et dont elle sollicite la protection, sont plausibles. Il en va ainsi du droit des Palestiniens de Gaza d'être protégés contre les actes de génocide et les actes prohibés connexes visés à l'article 3 de la Convention sur le génocide, et du droit de l'Afrique du Sud de demander qu'Israël s'acquitte des obligations lui incombant au titre de la Convention. Fin de citation. Comme cela résulte des faits exposés par Daniel Müller, ceci est encore bien plus plausible, pour ne pas dire avéré, aujourd'hui. Vous l'avez confirmé dans votre ordonnance du 28 mars en visant les conditions désastreuses dans lesquelles visent les Palestiniens de la bande de Gaza se sont, depuis le 26 janvier, encore détériorés. Et, je vous cite à nouveau, la situation actuelle dont la Cour est saisie entraîne un risque accru qu'un préjudice irréparable soit causé aux droits plausibles du peuple palestinien à Gaza. Les mesures sollicitées par le Nicaragua visent la protection de son droit à voir l'Allemagne respecter ses obligations en vertu de la Convention sur le génocide, ainsi que celle des droits concomitants du peuple palestinien qui est directement lésé par le comportement de l'Allemagne. C'est un droit, c'est aussi une obligation conventionnelle. Le même raisonnement s'impose sans la moindre hésitation s'agissant de la violation des grands traités protecteurs des droits humains ou de ceux qui témoignent et qui codifient le droit international humanitaire que j'ai énuméré tout à l'heure. En témoigne effroyablement l'enfer de Gaza dont vous avez fait état vous-même. Les exactions perpétuées par les colons israéliens dans le territoire palestinien occupé, avec le soutien du gouvernement israélien, dont sont victimes dans des proportions croissantes les Palestiniens de Cisjordanie. Ici encore, Monsieur le Président, je ne pense pas qu'il faille être devin pour anticiper les protestations de la partie allemande. Oui, la situation humanitaire à Gaza est préoccupante. Et nous, c'est l'Allemagne que je fais parler, nous nous en inquiétons et l'avons fait savoir. Mais nous n'y sommes pour rien. Nous ne commettons aucun des actes génocidaires énumérés à l'article 2 de la Convention de 1948 et n'avons nullement l'intention de détruire en tout ou en partie le groupe national, ethnique, racial ou religieux, quelle qu'en soit la définition, que constitue le peuple palestinien. Et je ne doute pas que cette attitude à la Ponce Pilate s'exprimera avec une égale bonne conscience au sujet des violations des droits humains et du droit humanitaire. Il n'y a pas de soldats allemands à Gaza, ni dans le territoire palestinien occupé. Et il faut comprendre, et on ne peut qu'approuver, le droit d'Israël de se défendre. À moins que, pris de scrupules, mes amis de l'autre côté de la barre fassent preuve de retenue sur ce point, et tant la disproportion de la riposte à l'attaque du Hamas du 7 octobre est monstrueuse, et alors que rien ne saurait, de toute manière, justifier le ciblage systématique des hôpitaux, des écoles et des distributions de vivres encore effectuées par les rares ONG qui arrivent à subsister à Gaza. Quoi qu'il en soit, il ne paraît pas douteux que l'Allemagne plaidera demain « c'est pas moi, Monsieur le Président, c'est pas moi, Monsieur le Président ». Si tel est le cas, c'est qu'elle se sera trompée de procès. L'objet de celui qui nous réunit est exposé de façon claire et précise dès le paragraphe 3 de la requête et réitéré dans les conclusions de celle-ci. Ce que le Nicaragua reproche à l'Allemagne, ce n'est pas, sous une réserve sur laquelle je reviendrai dans un instant, ce n'est pas de commettre un génocide dans la bande de Gaza ou en Palestine, mais c'est d'avoir manqué et de manquer à ses obligations, aux siennes propres, d'empêcher que ce génocide soit commis et de punir les personnes qui le commettent ou qui se livrent à l'un quelconque des actes énumérés aux articles 2 et 3 de la Convention. Ce n'est pas de violer les obligations s'imposant aux belligérants, ce que l'Allemagne n'est pas dans le conflit israélo-palestinien, ni à celles qui s'imposent plus spécialement aux puissances occupantes, ce que l'Allemagne n'est pas davantage. Ce que le Nicaragua lui reproche, c'est de ne pas respecter les obligations qui lui incombent, à elle, Allemagne, en vertu du droit international humanitaire, qu'il lui appartient de faire respecter en toutes circonstances, y compris en s'acquittant de son obligation de poursuivre, de juger et de punir les personnes responsables ou accusées de crimes graves au regard du droit international, qu'il s'agisse de génocide, de crimes de guerre ou d'apartheid. Loin de s'en acquitter, c'est pour l'Allemagne business as usual, ou plutôt, comme Daniel Müller l'a expliqué, business better than usual. Les ventes d'armes n'ont pas cessé, elles se sont amplifiées très considérablement. Le Nicaragua ne reproche pas non plus à l'Allemagne de pratiquer une politique d'apartheid contre le peuple palestinien ou de nier son droit à l'autodétermination. Ce qu'il lui reproche, c'est d'apporter une aide et une assistance au maintien de la discrimination raciale systématique et du régime d'apartheid dont ce peuple est victime, et de ne pas s'acquitter de son obligation de coopérer à la réalisation de son droit à disposer de lui-même, en fournissant à Israël une aide notamment militaire utilisée et utilisable pour en empêcher l'exercice. Et c'est bien à l'Allemagne, pas à un autre État, pas à Israël, que le Nicaragua reproche d'avoir privé l'UNRWA de son aide financière pour ses activités à Gaza, l'empêchant ainsi de jouer son rôle humanitaire irremplaçable dans l'enclave, au moment où ce rôle est pourtant le plus indispensable, en y facilitant du même coup les exactions israéliennes et en aggravant la famine, le manque d'eau et de soins médicaux et l'aggravation de la catastrophe humanitaire. Il en va de même de la demande en indication de mesures conservatoires dont notre agent va lire la version finale dans quelques minutes. Dans les limites inhérentes à la compétence de la Cour, elle concerne toutes et exclusivement la seule Allemagne, qu'il s'agisse de la suspension immédiate par l'Allemagne de son aide à Israël, en particulier militaire, dans la mesure où elle est susceptible d'être utilisée pour violer la Convention sur les génocides ou d'autres normes impératives du droit international général, notamment en matière humanitaire. Du déploiement par l'Allemagne de tous les efforts nécessaires en vue de s'assurer que les armes déjà livrées à Israël ne soient pas utilisées pour commettre un génocide ou de manière à violer le droit international humanitaire, ou encore de la révocation par l'Allemagne de sa décision de suspendre ses contributions aux opérations de l'UNRWA à Gaza dans le cadre du respect de ses obligations de prévention du génocide et de violations graves du droit international humanitaire. Il s'agit de demandes précises et spécifiques qui concernent toute la seule Allemagne et qui sont toutes de nature à alléger dans l'immédiat les souffrances du peuple palestinien et les atteintes aux principes les plus fondamentaux du droit humanitaire, ainsi qu'à atténuer la pression génocidaire dont ce peuple est victime. Monsieur le Président, je n'entends pas entrer dans le détail des griefs du Nicaragua à l'égard de l'Allemagne, mais je voudrais donner quelques exemples de leur existence autonome par rapport à ceux qui pourraient être adressés à Israël si ce pays acceptait la compétence de la Cour, hors la seule exception de l'article 8 de la Convention sur le génocide. Mais commençons par celui-ci, par le génocide. Je l'ai dit, sauf sur un point, il est vrai important, le Nicaragua n'accuse pas l'Allemagne de commettre un génocide contre le peuple palestinien à Gaza ou ailleurs. Ce dont il le rend responsable au premier chef, c'est de manquer à son obligation de prévenir et réprimer le crime de génocide, obligation qui pèse sur toutes les parties à la Convention de 1948. Cela ressort du titre complet de la Convention et de son article 1er, dans lequel, je cite l'article 1er, les parties contractantes confirment que le génocide, qu'il soit commis en temps de paix ou en temps de guerre, est un crime du droit des gens qu'elles s'engagent à prévenir et à punir. Qu'elles s'engagent à prévenir et à punir. Comme la Cour l'a souligné avec une grande fermeté dans la première affaire contentieuse sur le génocide qui lui a été soumise, et je vous cite, « L'obligation pour chaque État contractant de prévenir le génocide revêt une portée normative et une portée obligatoire. » L'Allemagne en est d'ailleurs bien consciente, elle s'est réclamée de ce devoir pour intervenir dans l'affaire du génocide contre les Rohingyas. Et elle s'en est expliquée plus précisément encore dans une déclaration du ministère fédéral des Affaires étrangères du 17 novembre 2023 que je cite en anglais. Germany feels it has a special responsibility to contribute to the fight against and the prevention and investigation of any potential genocide, and to send a message that states will be held accountable for all acts of genocide. Genocide concerns us all, wherever in the world it occurs. Well, I have never known how to use this. It was the first time I tried to use my phone. C'est cette obligation que l'Allemagne n'a pas respectée, c'est ce manquement que vous serez appelés à apprécier lors de l'examen de l'affaire au fond. Et je rappelle au passage qu'il s'agit d'une obligation de comportement et non de résultat, ce qui la différencie de celle de ne pas commettre un génocide, comme la Cour l'a également relevé dans son arrêt de 2007. Il en résulte, et c'est fondamental en ce qui nous concerne, que, je cite, l'obligation qui s'impose aux États parties est de mettre en œuvre tous les moyens qui sont raisonnablement à leur disposition en vue d'empêcher, dans la mesure du possible, le génocide. La responsabilité d'un État ne saurait être engagée pour la seule raison que le résultat recherché n'a pas été atteint. Elle l'est en revanche, si l'État a manqué manifestement de mettre en œuvre les mesures de prévention du génocide qui étaient à sa portée et qui auraient pu contribuer à l'empêcher. Fin de citation. Je sais bien, Monsieur le Président, que la responsabilité d'un État pour violation de l'obligation de prévenir le génocide n'est susceptible d'être retenue que si un génocide a effectivement été commis. Mais, comme la Cour l'a précisé également, cela ne signifie évidemment pas que l'obligation de prévenir le génocide ne prend naissance qu'au moment où le génocide commence à être perpétré, ce qui serait absurde puisqu'une telle obligation a précisément pour objet d'empêcher ou de tenter d'empêcher la survenance d'un tel acte. Ce devoir de prévention et d'action prend naissance au moment où l'État a connaissance ou devrait normalement avoir connaissance de l'existence d'un risque sérieux de commission d'un génocide. Dès cet instant, l'État est tenu, s'il dispose de moyens susceptibles d'avoir un effet dissuasif à l'égard des personnes soupçonnées de préparer un génocide, ou dont on peut raisonnablement craindre qu'ils nourrissent l'intention spécifique dolus specialis de mettre en œuvre ces moyens selon les circonstances. Fin de citation. Il ne saurait faire de doute, Monsieur le Président, qu'au point où nous en sommes, pour tout observateur, pour tout état de bonne foi, le seuil de prise de conscience est largement franchi. La plausibilité d'un génocide ou d'un apartheid, la matérialité des violations massives des règles les plus fondamentales du droit international humanitaire sont amplement dépassées. Au demeurant, au stade des mesures conservatoires, il vous suffit de déterminer d'une part la plausibilité qu'un génocide soit commis contre le peuple palestinien et d'autre part la plausibilité que l'Allemagne ne se soit pas acquittée de son obligation de mettre en œuvre tous les moyens qui sont raisonnablement à sa disposition en vue d'empêcher, dans la mesure du possible, le génocide et la violation de nombreux autres principes intransgressibles qui sont en cause. Sur la plausibilité d'un génocide, vous vous êtes prononcé par vos ordonnances du 26 janvier et du 28 mars dernier, et malheureusement, les choses n'ont fait qu'empirer depuis lors, comme Daniel Müller l'a montré, et elles empirent de jour en jour. J'ajoute que des actes qui, selon toute vraisemblance, relèvent de la définition du génocide, sont commis ailleurs qu'à Gaza, sur le territoire palestinien occupé. Or, l'Allemagne, non seulement n'a pas eu recours à tous les moyens dont elle disposait, notamment en tant que l'un des proches alliés d'Israël, pour faire cesser ces actes probables de génocide, mais elle continue à autoriser la livraison à une large échelle d'armes qui peuvent être utilisées pour le commettre. Toujours s'agissant du génocide, il y a autre chose. L'article 3 de la Convention de 1948, actuellement projetée, incrimine non seulement le génocide lui-même, tel qu'il est défini à l'article 2, mais aussi, entre autres, la complicité dans le génocide. Et dans son arrêt de 2007, la Cour a affirmé avec une grande netteté que la complicité, au sens littéra E de l'article 3 de la Convention, englobe sans nul doute la fourniture de moyens destinés à permettre ou à faciliter la commission du crime. Fin de citation. Élaborant davantage, vous avez relevé que, je cite, si la complicité est comme telle une notion absente de l'actuelle terminologie du droit de la responsabilité internationale, elle se rapproche d'une catégorie qui est présente dans les règles coutumières qui composent le droit de la responsabilité des États, celle de l'aide ou assistance fournie par un État à la commission d'un fait illicite par un autre État. Vous vous êtes référé à cet égard à l'article 16 des articles de la CDI sur la responsabilité de l'État qui exprime, vous le précisez, la règle coutumière suivante, et je le cite, « L'État qui aide ou assiste un autre État dans la commission du fait internationalement illicite par ce dernier est internationalement responsable pour avoir agi de la sorte dans le cas où, petit a, le dit État agit ainsi en connaissance des circonstances du fait internationalement illicite, et petit b, le fait serait internationalement illicite s'il était commis par cet État. » Fin de citation. Et vous avez précisé ne pas apercevoir, je cite, de raison d'établir une différence substantielle entre la complicité dans le génocide au sens du littéra E de l'article 3 de la Convention et l'aide ou assistance d'un État à la commission d'un acte illicite par un autre État au sens de l'article 16 précité. Comme le Nicaragua l'a montré dans sa requête, également complétée sur ce point par Maître Müller, l'Allemagne avait et a pleinement connaissance des risques d'utilisation des armes qu'elle fournissait et qu'elle continue de fournir à Israël en vue de commettre un génocide contre le peuple palestinien. Et il va de soi que le génocide en question serait internationalement illicite s'il était commis par l'Allemagne elle-même. Il est urgentissime que celle-ci suspende enfin l'aide et l'assistance qu'elle fournit à cette fin. Ces aides et assistantes entrent pleinement dans la définition de la complicité incriminée en tant que telle par l'article 3 de la Convention. L'urgence de mettre fin à la livraison d'armes qui permettent à Israël de mener son entreprise mortifère a encore été rappelée tout dernièrement par le Conseil des droits de l'homme et par la rapporteuse spéciale sur les territoires palestiniens occupés. Cette dernière a affirmé, je cite en anglais, faute de version française disponible, The Special Rapporteur urges member states to enforce a prohibition of genocide in accordance with their non-derogable obligations. Israel and those states that have been complicit must be held accountable and deliver reparations commensurate with the destruction, death and harm inflicted on the Palestinian people. Ms. Albanese called upon all states to, and I quote again, immediately implement an arms embargo on Israel, as it appears to have failed to comply with the binding measures ordered by the ICJ on 26 January 2024. Dans sa résolution de vendredi dernier, adoptée malgré le vote négatif de l'Allemagne, le Conseil des droits de l'homme a également exhorté tous les États à continuer de fournir au peuple palestinien une aide d'urgence, notamment une assistance humanitaire et une aide au développement pour remédier à la crise financière et à la situation socio-économique et humanitaire désastreuse, en particulier dans la bande de Gaza. Et il a souligné le rôle de premier plan que joue l'UNRWA, qui fournit des services essentiels à des millions de Palestiniens dans la région, et demandé à tous les États de veiller à ce que l'Office reçoive un financement prévisible, durable et suffisant pour pouvoir s'acquitter de son mandat. Le Nicaragua vous invite, mesdames et messieurs de la Cour, à joindre votre voix, revêtue de la force obligatoire qui s'y attache, à celle de la rapporteuse spéciale et du Conseil des droits de l'homme, qui, pour autoriser qu'elles soient, sont dépourvues d'une telle autorité. Ce raisonnement est transposable, mutatis mutandis, à l'appui des autres mesures que le Nicaragua vous prie de bien vouloir indiquer, et il l'est a fortiori car l'exigence du dolus specialis, qui est l'une des conditions d'existence du génocide, que vous avez d'ores et déjà jugé plausible, ne présente évidemment aucune pertinence s'agissant des violations du droit international humanitaire et des droits humains dont l'Allemagne doit être tenue responsable. Tel est assurément le cas en ce qui concerne ces mêmes fournitures d'armes qui ont pu servir, servent et risquent de servir encore à commettre des violations graves du droit international humanitaire, y compris des crimes de guerre ou le crime d'apartheid, alors qu'ici encore, elle ne pouvait qu'être pleinement consciente de ces risques et en tout cas de leur plausibilité. Ces obligations pèsent à l'évidence sur l'Allemagne et lui imposent de ne pas prêter aide et assistance à Israël dans ses actions contraires au droit international, mais bien au contraire, de mobiliser tous les moyens dont elle disposait et continue de disposer pour faire respecter le droit humanitaire. Il est d'autant plus crucial qu'elle s'en acquitte que l'Allemagne jouit d'un grand pouvoir d'influence auprès d'Israël, étant donné l'intensité des liens politiques qui unissent les deux États, liens dont l'Allemagne se prévaut en toute occasion. Monsieur le Président, l'Allemagne qui a tout fait pour se repentir de la Shoah, et c'est tout à son honneur, est choquée que l'on puisse, que l'on ose l'accuser d'aide et d'assistance au génocide, et même de ne pas respecter scrupuleusement les normes du droit international humanitaire également en jeu dans la présente affaire. Exactement comme Israël, qui se veut l'État du peuple juif, victime de l'hideuse Shoah. Et comme Israël est ulcéré que l'on puisse l'accuser de génocide. Mais personne n'est propriétaire de la marque génocide et aucun État, ni Israël, ni l'Allemagne, ne peut s'affranchir des règles fondamentales du droit international au prétexte qu'il peut se défendre ou aider la victime d'une attaque à se défendre. Vous devez, Mesdames et Messieurs les juges, le rappeler avec les moyens qui sont les vôtres, l'arme du droit, c'est ce que le Nicaragua vous demande. Monsieur le Président, avant de vous prier de bien vouloir rappeler à nouveau à cette barre l'ambassadeur Arguello Gomez, agent et avocat du Nicaragua, je tiens à vous adresser, Mesdames et Messieurs les juges, mes vifs remerciements pour votre écoute attentive. J'ai souvent eu l'occasion de prendre la parole dans le grand hall de justice, mais j'ai rarement, peut-être jamais, eu aussi vivement la conscience de la responsabilité qui pèse sur tous les acteurs, pas de la comédie, mais du drame judiciaire qui se joue dans cette instance. Cette responsabilité, elle pèse sur les avocats des parties, comme elle pèse sur la Cour. Je vous remercie.
Je remercie Monsieur le Professeur Pelé. And I will now give the floor back to the agent of Nicaragua, His Excellency, Mr. Carlos Arguello Gomez. You have the floor, sir.
Mr. President, members of the Court has heard from Dr. Mueller the facts which impel Nicaragua to initiate this case and this request for provisional measures. And Professor Pelé has just explained how Germany's conduct in relation to the ongoing situation in Palestine entails its responsibility under international law. That responsibility arises under two broad headings. First, Germany's responsibility for its failure to take the action required by international law to prevent and punish the commission of genocide and of serious breaches of international humanitarian law. And second, Germany's responsibility for its actions or omissions that have facilitated and continue to facilitate the commission of genocide and of serious breaches of international humanitarian law. That is, the responsibility for Germany's omissions and for its own acts. It remains for Nicaragua to address the criteria according to which the Court exercises its discretionary power to indicate provisional measures under Article 41 of the statute. The criteria are well established. There must be an admissible claim concerning a legal dispute over which the Court has prima facie jurisdiction. As to jurisdiction, Nicaragua relies on the declarations accepting the compulsory jurisdiction of the Court made by Nicaragua and Germany, respectively, under Article 36 of the Court's statute. As is explained in Nicaragua's application, there are no reservations in either declaration relevant to the present case. Nicaragua's reservation relates to matters before 1901 and Germany's to the deployment of its armed forces abroad in the use of German territory for military purposes. In addition, Article 9 of the Genocide Convention, to which both Nicaragua and Germany are parties, provides jurisdiction over certain aspects of Nicaragua's case. It is evident that these grounds, prima facie, afford a basis on which the jurisdiction of the court might be founded. The legal dispute was described in Nicaragua's letter of 2 February 2024, in which it specified the breaches of international law for which it considers that Germany is responsible. The breaches relate to obligations under the Genocide Convention, the 1949 Geneva Conventions, and additional protocols, and customary international law. Germany announced its rejection of Nicaragua's claims on 7 February 2024. Nothing more was heard from Germany on the subject on a bilateral level, but Germany continued to reiterate publicly its support for Israel, evidencing the difference of positions with Nicaragua and the subsistence of the dispute. On 1 March 2024, Nicaragua filed this application with the court as the only avenue holding out any hope of swiftly upholding the application of international law. The timescale and bilateral level of intercourse was not lengthy and extensive, and that is as it should be in a case where the allegations concern an ongoing genocide and grave violations of international humanitarian law. It would be a blind retreat into formalism to require round upon round of diplomatic exchanges to reiterate the flat rejection of Nicaragua's claims that Germany had made on 7 February and its reiterated public support of Israel's actions in Palestine. This rejection was again evidenced in Germany's note verbal of 11 March 2024. Mr. President, Nicaragua's claim is plainly admissible. This question has been discussed in Professor Pellé's presentation, but it is relevant to emphasize it in the context of the criteria for ordering provisional measures, which is here under discussion. As a contracting party, Nicaragua has a legal interest in the protection of the rights secured by the Genocide Convention. The point was reaffirmed earlier this year by the court in the context of South Africa's request for provisional measures. It is plain that the same is true in respect of the 1949 Geneva Conventions and additional protocols and of customary rules of international humanitarian law, which they embody. The court itself has said, I quote, that all states parties to the Geneva Convention relative to the protection of civilian persons in time of war, 12 August 49, are under an obligation while respecting the United Nations Charter and international law to ensure compliance by Israel with international humanitarian law as embodied in that convention. I'm citing your advisory opinion on the Wall case. These are obligations erga omnes or erga omnes partes, and each other state or state party has an interest in compliance with them in any given case. The court's jurisprudence refers to 4 other considerations to be taken into account in answering a request for provisional measures. 1, the plausibility of the rights claim. 2, the link between the provisional measures sought and the rights underlying the main merit claim. 3, the risk of irreparable harm, and 4, the urgency of the need for provisional measures. They all go to the basic question whether provisional measures are necessary in order to preserve rights which may subsequently be adjudged to belong to either party in the case. The plausibility of the rights claim and the link with the rights sought required are evident in the present case. As in the South Africa versus Israel case, there is here, and I quote, a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party, end of quote. And the same is true of rights under the Geneva Conventions and international humanitarian law. The rights of members of groups protected under the conventions and international humanitarian law, here the Palestinians, are self-evident. They include the right to be spared from genocidal attacks and treatment that fails to reach even the basic standards of international humanitarian law. Nicaragua seeks to secure compliance with the obligations that underpin those rights. But in this action against Germany, it is not for compliance with the obligation to refrain from such attacks. Rather, as already stressed by Professor Pelé, the obligations of Germany that are in question are its obligations to take actions to prevent or punish breaches of the Genocide Convention and of international humanitarian law, and to refrain from complicity in or facilitation of such breaches. These obligations have indisputably arisen in this case. The existence of this obligation for states parties to the Genocide Convention and its engagement in respect to the attacks in Gaza has already been determined at least since the order of the Court of 26 January 2024. It can scarcely be denied that the same is true in relation to the obligations to prevent and punish breaches of the Geneva Conventions and of international humanitarian law, as Professor Pelé has explained. The Palestinians are being denied the rights to protection and are dying and being injured and having their homeland reduced to rubble because of it. Similarly, Nicaragua is also requesting provisional measures on the basis that Germany is not only failing its duties to prevent and punish these breaches, but that it is complicit in them by aiding and assisting the commission of the breaches. The facts in Gaza and the other parts of the Palestinian-occupied territory are notorious. They have been filmed and reported on and broadcast for the past 6 months, in spite of the difficulties and the more than 100 journalists killed. In its last order of 28 March 2024, the court referred to, and I quote, the catastrophic situation in the Gaza Strip and the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, end of quote. Germany cannot but be aware of these statements by the court. In fact, Germany has announced its intention to intervene in the case lodged by South Africa in favor of Israel. So it is obviously aware of the orders of the court in this case. Mr. President, Germany cannot but be aware that the munitions, the military equipment, and the war weapons it is supplying is being used by Israel in these attacks. It does not matter whether an artillery shell is delivered straight from Germany to an Israeli tank shelling a hospital or university, or whether that artillery shell goes to replenish Israel's stockpile for use at some later date. It doesn't matter whether the planes used in combat and to drop one-ton bombs on the population were made entirely in Germany or just their spare parts and maintenance were supplied. The fact is that the assurance of supplies and replacement for armaments is crucial to Israel's pursuit of the attacks on Gaza. That much is evident from the emergency arrangements made by states such as Germany and the United States, among others, to continue with military supplies to Israel, even during the actual conflict and in the face of daily breaches of international humanitarian law. These are the rights that Nicaragua invokes, and their plausibility is beyond question. But there's another aspect. Nicaragua is also seeking here to protect its own distinct rights under international law, which raises a principle of the greatest importance. Those distinct rights are the rights entailed by accession to multilateral conventions in which all parties bear individual responsibility for securing the aims of the convention. Those responsibilities necessarily require each state party to conduct itself in a manner that does not undermine the aims of the convention. Certainly, there are many states and organizations calling for compliance with international humanitarian law and observance of what the court has called elementary considerations of humanity in Gaza. But there are also states pouring gasoline on the fire. There are states that continue to supply or to permit companies within their jurisdiction to supply munitions of war to Israel, knowing that such weapons are being used against Palestinians in violation of international humanitarian law and elementary considerations of humanity, and are thereby actively undermining these rules and principles. Sadly and shamefully, there are also important business interests that are profiting from this ongoing Nakba. The important point is that such undermining is breaking faith with the other states that are committed to securing the basic rights and protections embodied in international humanitarian law. In more strictly legal terms, such conduct breaks the duty of cooperation in the promotion of the aims of international humanitarian law. That duty to cooperate is a general principle of international law with its own chapter in the Declaration on Principles of International Law of 1970. Specifically, it is at the heart of the undertakings in Article 1 of the Genocide Convention and in Common Article 1 of the 1949 Geneva Conventions and the 1977 additional protocols to the Geneva Conventions and the Apartheid Convention and the basic principles of international humanitarian law. It applies to all states, erga omnes or erga omnes partes. The point is that while cooperation may require much in the way of good faith efforts to pursue internationally agreed policies, it must require that insofar as a state is bound by a duty of cooperation with other states, the state must, at a minimum, refrain from actions that undermine the efforts to secure the common goals. The principle might be inferred from the broader principle of good faith. And in relation to cooperation concerning substantive duties set out in treaties, is underpinned by the rules on treaty interpretation. This focus on cooperation recognizes that while Germany happens to be one of the handful of states whose support for Israel is particularly important and a particularly direct contributor to the continuation of Israel's attacks, as a matter of law, it is obliged to cooperate with other states in using its best efforts to bring these breaches to an end. And as a matter of practicality, it will have to do so if its efforts are to be effective. Nicaragua does not at this stage ask the court to make extensive orders regarding the entire range of Germany's legal duties to take positive actions in order to ensure compliance with the Genocide Convention and international humanitarian law. Nicaragua asks only that the court order that Germany refrain from undermining that aim and making the situation in Gaza worse by providing or allowing the provision of munitions of war and other direct support for Israel at this juncture, and by depriving UNRWA, the organization that is uniquely equipped to deliver humanitarian aid in Gaza, of funding and of the ability to continue working in accordance with its mandate. Mr. President, this is the explanation of the provisional measures requested. The first request an order that Germany suspend its aid to Israel, in particular its military assistance, including military equipment, insofar as this aid is used or may be used in the violation of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. This requires a halt to the execution of any agreements for the supply of material or services that could be used or are being used by Israel for its attacks. In view of the recent news on the possible more massive supply of weapons to Israel, it is necessary to add this note on this point. It is public knowledge that Germany collaborates with the United States in several military programs related to a fabrication of equipment and spare and replacement parts, technical and logistical support, among other aspects. The United States is in the process of approving a plan to sell $18 billion worth of F-15 fighter jets to Israel, a new order for F-35 jets, and an additional $14 billion in military aid, including weapons and technology for our missile defense. If this new deal by the United States involves Germany, Nicaragua wishes to make clear that this collaboration with the United States or any other associate must cease in the current context and should also be considered as part of any measures the court might decide to adopt. Mr. President, the second measure requested requires Germany to use whatever legal or contractual powers and whatever influence it has over Israel to ensure that weapons already delivered by Germany and German entities to Israel are not used to commit or facilitate serious violations of the Genocide Convention or of international humanitarian law. The third request seeks an order that, As part of its duties to prevent violations of the Genocide Convention and international humanitarian law, Germany resumed its funding of UNRWA for its activities in Gaza. The crippling of UNRWA appears to be the biggest impediment to a distribution of humanitarian aid to the Palestinians who need it most, part of what the European Union and the United Nations have referred to as the weaponizing of hunger by Israel. The request thus focuses precisely on a step that Germany can take that will have great practical effect in alleviating the suffering and destruction. The submissions do not formally request the Court to recall to the parties the obligation of compliance with humanitarian law, as well as the obligation of cooperation to bring to an end all serious breaches of peremptory norms of international law. The reference in the submissions is simply a reminder of existing obligations that do not need to be specially ordered by the Court. The link between these measures and the rising issue at the merit stage is obvious. The measures requested are conservatory. They are needed in order to ensure that Germany stops aiding and abetting the complete devastation of Palestine, and that Gaza in particular is not completely devastated before the Court hears the merits of this case. For that same reason, the urgency and necessity for the measures is, Nicaragua submits, as obvious as it could possibly be. The killing and the destruction are continuing even as we sit in the Peace Palace of the Great Hall of Justice, at the heart of the only really global institution mandated to uphold the rule of law. Mr. President, members of the Court, in considering the request for provisional measures, I will call attention to the importance that the decision of the Court be addressed to ordering concrete measures that admit of no rationalizations in their compliance. An order by the Court that simply recalls clear pre-existing obligations that should be complied with without any specific order would not be effective. In the course of these pleadings, we have referred on several occasions to the advisory opinion on the construction of a wall. In this opinion, the Court considered the legal consequences of the internationally wrongful acts of Israel as regard other states. The situation then involved actions that, in comparison to what is now under consideration, would seem almost trivial. Yet the obligations then also under consideration involved similar peremptory norms of international law that, in the present circumstances, apply even more forcefully and urgently. Mr. President, briefly, in that case, the Court reaffirmed the obligation of all states not to recognize the illegal situation created by acts contrary to peremptory norms. Then the actions under consideration were the construction of a wall. In the present case, the destruction of a people. The advisory opinion reaffirmed the obligation not to render aid or assistance in maintaining that illegal situation. It specifically recalled the obligation, I quote, to ensure compliance by Israel with international law as embodied in the Geneva Convention, end of quote. But in dealing with the construction of a wall, the Court did not limit itself to refer directly by name to one state, Israel. It also recalled the obligation of all states to ensure that Israel complied with international humanitarian law. An advisory opinion certainly is not a binding decision within the scope of Article 59 of the statute, but it represents a statement by the highest judicial organ of the United Nations on the law in force. States that do not act in accordance with international law as interpreted by the Court are not violating a judgment of the Court. They are simply violating international law. Mr. President, if the obligation of all states with respect to the actions of Israel in Palestine, as stated in the Wall Advisory Opinion, had been complied with, we would not be here before you today. This is why we consider that the measures ordered by the Court should be clear, specific, and of unavoidable compliance. Germany, as all other states of the international community, has been aware, at the very least since the year 2004, when the advisory opinion on the construction of a wall was given, that peremptory norms of international law imposed the obligation not to render aid and assistance to Israel in its violations of international humanitarian law as embodied in the Geneva Conventions. As we have pointed out in our application in the course of this pleading, Germany, as all states of the international community, has been aware since at least the 9th or 10th of October that serious violations of international law were being committed by Israel in Palestine, and at least as from the date of the order of the court of 26 January of the possibility that these violations constituted a crime of genocide. In Germany, as of today, ignoring its glaringly obvious obligations, continues providing assistance to Israel. Mr. President, this has got to stop. That is why we have come before you and why Nicaragua makes the following submissions. I will proceed, Mr. President, to read Nicaraguan submissions. Nicaragua respectfully requests the Court, as a matter of extreme urgency, pending the Court's determination of this case and the merits, and after recalling to the parties the obligation of compliance with humanitarian law, as well as of the obligation of cooperation to bring to an end all serious breaches of the peremptory norms of international law, to indicate the following provisional measures with respect to Germany and its participation in the ongoing plausible genocide and serious breaches of international humanitarian law and other peremptory norms of general international law occurring in the Gaza Strip, as well as in other parts of Palestine. Namely, to order that, 1, Germany must immediately suspend its aid to Israel, in particular its military assistance, export and authorization of export of military equipment and war weapons, insofar as this aid is used or could be used to commit or to facilitate serious violations of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. 2, Germany must immediately ensure that military equipment, war weapons, and other equipment used for military purposes already delivered by Germany and German entities to Israel are not used to commit or to facilitate serious violations of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. 3, Germany must resume its support and financing of UNRWA in respect of its operations in Gaza. This is the end of Nicaragua's ambitions. Mr. President, members of the Court, this concludes Nicaragua's pleading. Thank you for your kind attention. I would also like to thank the registry and its staff and the interpreters for their invaluable assistance. My thanks also to the Nicaraguan team. Thank you.
I thank the agent of Nicaragua, whose statement brings to an end the single round of oral argument of Nicaragua, as well as this morning's sitting. The court will meet again tomorrow, Tuesday, 9 April, at 10 a.m. to hear Germany present its single round of oral argument. The sitting is adjourned.